And since it was a Republic Day, we thought, why not understand the basics of land laws? And we had requested Justice Rajive Bhalla, and per chance, yesterday he was tested positive. But the positivity to teach the society at large shows his volume. So he said that he's having a bad throat and other issues. But be that as it may, I was talking to him off the platform that I'm reminded that when the player got injured and he continued to play for India, and we all know about it. And I said that the grit to share the knowledge speaks volume about sir. But though we have done a lot of sessions on the revenue law with Justice Rajive Bhalla, but we time and again get the request that the basics of the land law should be explained in a subtle manner. And just on the chat box, I'm seeing that Dr. Shikha Diman has also joined. I welcome her also. And let me see all those persons who are familiar faces. Mr. Anurag Jain is there. And a lot of people. Sir has his own following in his own way. And without taking much time, since I know that sir is not well, but his will to teach to all of us shows that where there is a will, there is a way. Without taking much time, I request sir to take over the platform. Over to you, sir.
Thank you. Thank you, Vikas. And you left out one name, probably you don't know him. I think we have Professor Dr. Pavan Kumar from the chairperson of the Dr. Pavan Kumar of the Guru Nanak Dev University. He's also here today.
Yeah, I will just unmute him.
So I hope I hope he can hear me.
Yeah. We have also made him a request for unmuting himself. Yes, over to you.
Dr. Pavan Kumar, thank you for joining.
Good evening, sir. Good evening.
Thank you for joining. And since this is a
thank
topic,
you, sir, providing us this opportunity to join this webinar, and our whole faculty will join this webinar, sir. Thank you, sir, for providing this opportunity to us.
Thank you very much. I hope as much of you as possible, because this is a topic which is important to North India, particularly, but land is common to everybody. And we can't say that it is only common to the North. But since we are dealing with land laws, and basically the rights in land are the same and identical almost all over the country, what I'm going to do today is to take you to common land. In the north of the country, in fact, up to maybe UP, in fact, Himachal, Punjab, Haryana, Rajasthan, Delhi, common land is called Shamla De. I'm sorry, there's somebody from the south. I don't know what it's called in the south. Common pasture land, where the common people in the village use the land for pasture, or they can use it for extension of the village of Abadi, etc. So I express my inability to talk about the rest of the country. But still, I think all those who are there from other parts of the country should try and understand what it is exactly, as to why is there so much litigation in the north around common land. And I can just start by giving a brief origin of common land. You all remember and you all know that there's a very famous book called From Treetops to Houses. The book traced the history of human beings from how they came down from trees and into savannas, into pastures, and eventually into houses. So when they left the forest and they began to settle and they began to cultivate, that is the time this concept came, where a group of families or people came and collected together, and they formed this loose unit, which eventually developed into a village. While they were doing so, they also realized, and in fact, that is the original, call it the communist commune, but that is the original commune we had, where they had common facilities, and you could use the common land for whatever purpose you wanted. The purposes gradually began to be defined, and gradually the entire thing came into a document, which eventually, when the British came to this country, they made that document for each village. In the north, each village has that document. I'll just come to that later. But this common land, which was kept in the middle, not in the middle of a village, but in a village, was used for congregation of people, for a common pasture, for even if there was a forest there, people could go and collect firewood. So I'm talking about a few centuries ago, or maybe coming up to the 1940s or 50s or 60s, before we had electricity and before we had gas, and people used to collect firewood for their daily needs. It was important. Firewood is important. So you had to have a common land. You had to have rights in that. Who could collect the firewood? Who could not collect the firewood? Who could go and use the pasture? Who could not use the pasture? Whether he would pay for it, who could cultivate it, who could not cultivate it. So all these rights evolved over a period of time. And the land, common land, which somehow, I don't know, the British probably did not understand a little bit of some parts of it. They refer to it as culturable waste. And for them it was waste, but it was the common land. And it has a name in, it's an Urdu term, or call it a Persian term, or call it an Arabic term. It's called Shamlat De. Shamlat means common. You must have heard this word used at many places. Shamlat, common. De means land. So this is what is today's little chat with you all. I may not be able to take it much longer because my throat may pack up somewhere in the middle, but I'll try and my best to keep it going as much as I can. So the question, what I'm going to answer, or what I'm going to introduce you today, is the rights in Shamlat De. Now, Shamlat De is a peculiar variety of land. I don't know whether we have such common pastures or such common lands all over the world. But the only person who had a right in common land were not the entire village community. So please understand, Shamlat De does not mean the entire village community. It does not even mean all the owners in the people who own land. No, it's not that way. It just means the descendants of the original proprietors. Now, the original proprietors is again a term which gets misused at many places. It means they are the descendants of the original settlers of the village. People who came to settle the village. They are called proprietors, and there's a whole list maintained by the Revenue Department of who are the original proprietors, and they would have a shareholding in this land. This topic gets a little technical also, because it is technical. It's not a topic which is where you can discard the technicalities. So these are the people who had share in this land. And this land was identified. Their shareholdings were identified. They could sell the land. They could lease the land. They could partition the land, but only if permitted. Now there was, like I use the word, a communist commune, where everything is common to everybody. The law also was common in the sense that it's not just one person can get up and say, I'll partition this land, this is common land. No, the law of that village, and not the law of the state, not the law of that part of, if you can remember, India was different states, different countries, different kingdoms, different everything. It was the law of that village. And that document was called Sharat Wajibul Lads. That's called the law of the village. It had all the laws, and particularly with respect to common land, it would give everything to you in that. Now, these people who were, just a minute. If anybody is interested in going into the details of common land, please go to a book called Rattigan's Digest on Customary Law. Rattigan was a person who probably traveled all over the north and put down these laws, all customary laws of each village, of each district, each community. And as you know, customary law changes from community to community, and within a community also there are different. So he set down all these laws. So he also set out these laws, common land also is chapter 10 of that. Please, if somebody wants to read it, please do it. If somebody wants me to share it, I'll share that page with them after this is over. I have a extract of that with me, which I use everywhere. So now the owners, or I can even move a little to the Hindi language also. ये जो शामला दे थी, इसमें हिस्सेदार दो किस्म के हिस्सेदार थे. एक तो थे जिनका मालकी हक था. दूसरे थे जिनका possessory title था. I hope you all understand the difference between the two. वो जो उनका possessory title था, वो it depended on the malkana, the people who were owners. So people who were not owners were known as Malkan Makbuza Khud. I hope you understood the words. Or I'll leave out the words. I'll leave out these words and make it something that's difficult to understand. But if somebody wants it, there are two types of people. One who are owners and who are only have possessory rights but no proprietary rights. Yes, somebody's put up the book also there, and you can all have a look at that. So this is what it is, basic introduction. Now, this common land is not just Shamlat De. I'm trying to keep the topic a little simple today and a little not taking it to its full panoply of all. But this common land is also again of different varieties. It's not just Shamlat De. I'll just rattle off the different varieties, and many of you will be familiar with it. One is Shamlat De. One is Shamlat Patti. It's important to get the expression right. Lots of lawyers and lots of people, from judges also from this side of the bench also, don't get the expression right. Therefore, then they end up making mistakes. So it's Shamlat Patti. Then there is Shamlat Taraf. Then there is Shamlat, there are Pannas. And then there are Tholas. If you can. So it's Shamlat Patti, Taraf, Pannas, Tholas are all other types of common lands. Some of them will have Shamlat written before it. Some of them will not have Shamlat written before it. There is also another technical part to it, which I will explain to all of you in a different lecture. Because it's always good to, in the age of OTT, it's always better to leave something hanging for season 2. You don't do everything in one season. So with these words, now Shamlat De I explained to you, correct? But there was a problem with Shamlat De. People would, there is already a question. Mr. M.I. Khan has asked a question. I think I'll answer it right here. He says, De means Abadi. No, Abadi means the residential area of the village. That is Abadi De. There's a confusion between that. I'm not going to that, but I'll explain it at the end, Mr. Khan, if you can wait. So I'll just explain that at the end. What's the difference between De means land? Okay. So coming to now Shamlat, common land. For the moment, let's leave another variety of common land which are not dealt with is Abadi De. Now I'll deal with that, which Mr. Khan was saying Abadi De. Abadi De is that part of the land of a village, and within the village, if any of you has attended any of my other lectures, I've already done the village part as to how is a village constructed and how is a village made and what are the various components of a village. But I'll just repeat it again. You start with a hadbast, which is the delimiting of the land of the village. Then within the land or within the village is the cultivated area, plus the Shamlat, private ownership land, and plus Abadi De. Now, Abadi De is that area of the land which under the Punjab Land Revenue Act is not demarcated into different khasa numbers. And therefore, the Patwaris do not make separate khasa numbers for them. But the Abadi is given Abadi De as distinguished from Abadi. Abadi is a residence. Abadi De is the residential area of the village. It is delimited by the Phirni and the Lal Dora. That's just a red line on the map. Phirni is the road of the village. Now the land within the Abadi De is actually also the common land of the village. All proprietors are equal owners in that land. And again, the same principle applies. But since their house is there, so the person in possession is deemed to be the owner. It's a classic example of possession leading to ownership, or possession following ownership, or vice versa. It's a very rare fact in proprietary rights, that where your possession would confer proprietary rights to you. But then there's another problem which somehow, I don't know, now it's being resolved, or whether the Patwaris are doing it, but people are selling land within the Lal Dora, and sale deeds are being registered. Though actually legally they're not supposed to be registered, but they do it nowadays. Probably things have changed, and times have changed, and people don't understand things anymore. Because they can only give you possessory rights. They can't give you proprietary rights. Proprietary rights are with the entire village, meaning thereby the proprietors. So within Abadi, why this is all important is, these days, all big cities have abutting them large chunks of land, which are Shamlat land, common lands, which are lands which are common lands, which are being sold to people by a fictitious partition, and then showing the person to be owner of that book. So a small request to you, when the sale deed does look suspicious, or probably it will not look suspicious to you, please go back 2-3 Jamabandis, and you will find them all. So I hope that is very, very clear with you. There is no question of having a separate Khasa number in the Abadi. Why this is important is because the governments have actually encroached upon the rights of the proprietary body in villages, and made laws where vacant land has been vested in the panchayat. That I'll come to later. Has vested in the panchayat under what legal theory, or under what legal rights, nobody seems to understand, and nobody has ever questioned also. Because if that was the property of the proprietors, the government could not have taken it away without paying compensation. So this is one aspect of the case somebody needs to examine. So please do that. Though I'll deal with that. I'll answer that myself somewhere down the line. Then we come to a second variety, Shamlat Patti. The word is Patti. Many of us will speak it as Patti or some other this thing, but it is Shamlat Patti. Now, within the Shamlat of a village and within the residents of a village, there are different types of residents who may belong to a particular caste, a particular creed, a particular profession, or even a particular religion, though actually religions were not Pattis. But soon people, now you're finding Pattis from the last 30-40 years, which will have names like Patti Brahmana, Patti Khatriya, Patti so-and-so, which actually would never be like that earlier. Now, in this, what happens is there is a limited body of the proprietary body. People who belong to that community or that sub-community or that religion or that, like there used to be Patti Kumhara, people who were Kumhars, people who were potters, they would be part of it. So it was that land vested only in them and not in the entire proprietary body or the others also who were not proprietors but who had purchased some land. I hope that's clear. Patti is land which belongs to this very body who has reserved this land for its own members. Patti. Similarly, Pana, Thola and Taraf are similar. Now what has happened is the government has in Haryana conferred proprietary rights on owners, on people in this. Now, why this is also important is because when you come to the Punjab Village Common Land Act 1961, which applies to both states with a few amendments, there are certain situations in which these lands surprisingly vest in the Gram Panchayat. I'm purposely doing this so as to enable you to think. I may be agreeing with what the governments have done or what legislatures have done, but still I think it's important to understand how rights got vested in panchayats. And I hope nobody minds my having my cup of tea because my throat will keep warm, then I'll keep speaking. So Patti, Panna, Thola, when you'll open the Village Common Land Act, you'll find these in section 2G expressions. But they're not defined there. For that, you'll have to go to a different book. I'm not taking you over there right now. So Shamla De, we are through with these varieties. There's another 4 varieties of Shamla De. And then there's one very, 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 very important variety of Shamla De. In Haryana, it is Shamla De. In Punjab, it is not Shamla De. That is a dichotomy between the 2 states. So now I will take you to this variety of Shamlat. When the villages originally existed, there was only Shamlat De. But when we enacted the Consolidation Act in 1949, a need was felt that there needs to be some more common land in a village, and maybe these are not enough. So they enacted this Consolidation Act. I'm not giving you the sections as yet, I'll do that later, which allows the consolidation officer during the preparation of a consolidation scheme. Though you can remember, consolidation means to put together the land. But the government, in a way, maybe because though that act has been upheld by the Supreme Court, eventually the government said, let's put all of them together and we will apply a cut on the holdings of the proprietors. Now remember proprietors again, because this is very important to understand that it will be on a cut on the proprietors, not on everybody. And from that cut is created a common land called Jumla Mushtarka Malkan. It's a tongue twister for people who are not familiar with it. Jumla Mushtarka Malkan wa Digar Hakdaran Hasab Rasab Zare Khevat. काफी difficult है ना ये word, लेकिन if somebody here is familiar with it, he can put it up in the chat box. It's in rule 16.2 of the rules. If somebody can quickly take it out and put it up in the chat box. Jumla Mushtarka Malkan wa Digar Hakdaran Hasab Rasab Zare Khevat. Now what does this ये अजीब सा एक फिक्रा है, क्या इसका मतलब क्या है? इसका मतलब बड़ा सिंपल सा है, छोटा सा मतलब है कि ये जो जमीन है ये कॉमन पर्पसेस के लिए यूज की जाएगी और इसकी पोजेशन जो है वो ग्राम पंचायत के पास होगी. By the time ग्राम पंचायत had come, we had the 1952 Punjab Gram Panchayat Act, which applied to Haryana, Himachal, everybody, to all the states, everybody. Everybody's acts came separately later on. And they said that, okay, this is but the ownership will vest in the proprietors. जिसके ऊपर आपने कट लगाया वही मालिक होंगे. And it is written in 16.2, rule 16.2 of the rules. Can someone put it up in the chat box? Anybody who had put up that so anyway, we'll put it up later if nobody can do that, so that everybody can see it.
So we will share it in the WhatsApp group.
Please do that. Please do that. So rule 16.2 of the rules says that you create another type of common land. And it was for the first time that the word common purposes was defined under section 2BB of the Consolidation Act. 2BB. Common purposes, there was no definition earlier. And then this definition was followed in the Village Common Land Act, it was followed in the Gram Panchayat Act, it was followed in various other things. But this is what the entire thing was about, how to create common land where there is not sufficient common land. This having been done, the question that arose, and many disputes arose in the high courts. There were full benches. In the Supreme Court, the matter went up to the Supreme Court eventually, that how can you take away property from private individuals and create land in which everybody would enjoy it? How can you do that? And without paying compensation to the village community or to the people? So the Lordships of the Supreme Court, this is in the 60s, I'll share all those judgments also, held that yes, the possessory rights are taken away, but the proprietary rights remain. And for what purpose? For the common purpose of these very people from whom it has been taken away. And who administers them? They themselves. Through whom? Through the Gram Panchayat. So that's how, in a circuitous route, the Supreme Court said that it is your land. Management has only been given to them, not to anybody else. So this was upheld by the Supreme Court. But now what's happened is, and that matter is also pending before the Supreme Court now. Now what happened, Haryana came out with legislation that this land will all vest in the Gram Panchayat. They will become owners. It will become Shamlat De. Earlier it was Jumla Mushtarka Malkan, not Shamlat De. So the Haryana government has held, Punjab has not done it. So on this aspect also, this matter is pending in the Supreme Court as to, because then the High Court said that if you've taken it away for the purpose of a village, and it was upheld by the Supreme Court on the ground that you are only taking it for the management of the people of the village. So now if the government is going to make them the owners, you're taking away their rights. Then the question came, when this land would come into municipal committees, would the municipal committee become the owner? What would happen? So that question has also been answered by the High Court in a judgment. And that matter is pending before the Supreme Court. So I don't want to opine on that because that's of a very dear colleague. So I don't want to say anything on that judgment. But once we have looked at common land and we have decided that this is the common land, the varieties I will again explain to you: Shamlat De, Shamlat Patti, Shamlat Panna, Shamlat Thola, Shamlat Taraf. These are words which you will encounter in the Punjab Village Common Land Act. And this Jumla Mushtarka Malkan, Ba Digar Haqdan Haran, Hasab Rasab Zare Khevat. Again, a slightly difficult word, but you'll have to read it. If you have to live in this north part of the country and be a lawyer who does land laws, you'll have to read all these things. Now, coming to what happened eventually, I've taken you straight away to the vesting of by the state of Haryana. So, what happened after independence, there was a vision in the country that we must now free up lands from feudal families and from feudal areas, like it used to be that maybe one person was owner of 500 acres of land or one person was owner of 10 villages. So slowly this process began. And in Pakistan, we still have that. They've still not implemented all that. So the first act that came out in this was the Punjab Gram Panchayat Act, 1952. When the Punjab Gram Panchayat Act came out, the government suddenly felt the panchayat has got no land. So how do we give them this Shamla which these people are administering? So then came two very, very important acts. One is the Punjab Common Land Act 1953 and one is the PEPSU Common Land Act 1954. Maybe some of you will not be aware of what is this Punjab and PEPSU. Punjab was divided into Punjab, which was the British ruled area, and PEPSU, which was ruled by the 5 or 6 princely states which are merged with India. That was PEPSU. Eventually, they also came and joined Punjab, and PEPSU demerged from itself and became part of Punjab. So when these 1953 acts and 54 act came, they only had one sentence and only one exception. So all land recorded as Shamla De shall vest in the Gram Panchayat. No exception. Nothing if you were in possession for the last 100 years. Nothing if you, whatever you want to do, I mean, it's all gone. You are finished. It's all over. You can't do anything in this. So it all goes to the panchayat. But then probably people thought, no, this is too draconian. And you're not even paying compensation, not paying anything. So what do you do then? Then they repealed these two statutes. In the meanwhile, they had been quashed by the High Court also, these two acts, and they came out with the 1961 Act. Now that is where I'll take you directly. This is called the Punjab Village Common Land Act 1961, which is still in force, fortunately, which is still in force, and which defines what is common land. There's one very famous section called Section 2G of this Act, which defines what is common land. And I'll just read that out to you. It starts just like the 1953 and those acts. But before I do that, I'll just take you to a little definition. Of Section 2BB and how things changed. 2BB of the Consolidation Act. It enumerated all the common land, everything, and how it changed over a period of time, and how the courts eventually upheld it. It's a very long topic, but I have the limits of time, and I also have the limits of my throat a little bit. So I'll just take you quickly. It gives you the 1 minute. I think there's too much of stuff around. One minute, I think I've just misplaced the book. Just a minute. I'll just switch off for a minute and I need a little. Sorry, I'm back, but there was a little problem because I'm not in my office and I am in isolation. So I've just been managed to get these books. So 1961 Act I was taking you to the 53 Act. So I'll just show you what the 53 Act said. It said vesting of rights in panchayat and in non-proprietors. Please remember the word is being used as non-proprietors also. Notwithstanding anything to the contrary contained in any other law for the time in force, and notwithstanding any agreement, instrument, custom, or usage, or any decree or order of any court and other authority, all rights, titles, and interests, whatever in the land, which is included in Shamla Day of any village. It made no exceptions for Patti, Panna, Thola shall vest in the Gram Panchayat. Yeah, see, that's why it was so draconian. Then comes the 61 Act, which started loosening up this law of common land, and under section 2G, there are three important sections in this act. One is section 2G, section 3, and section 4. I'm sorry for taking some time because the problem is my office is not functioning. I'll just quickly explain to you section 2G. It's not an exclusive definition, it's an inclusive definition. It says Shamla De includes land described in the revenue record as Shamla De or Charan. Now, Charan means land which is used as Shamla Tikkas, land described in the revenue record as Shamla Taraf, Pattis, Panas, and Tholas. So what exception they did for Shamla Taraf, Pattis, Panas, and Tholas is used according to the revenue record for the benefit of the village community or a part thereof or for common purposes of the village. This part has been interpreted to mean for the entire village and not for any particular part. This second part has been held to be different. Now coming to then 4. Land used or reserved for benefit of the village community, including streets, lanes, playgrounds, schools, drinking wells. This is all within the Abadi De or outside, and common purposes of village under section so and so. Vacant land situated in Abadi De or Gora De. This is another important thing which has come in one state, other state doesn't have it. Lands in any village described as Banjar Kadim and used for common purposes of village according to the revenue code. Now, Banjar Kadim, I think you should all understand what is Banjar Kadim. But does not include. This is the most important. This is where most of the people got their lands excluded. Does not include land which becomes or has become Shamla De due to river action. This is gone now. This is no longer there. Has been allotted on quasi-permanent basis to a displaced person. This is there. Has been partitioned and brought under cultivation by individual landowners before the 26th of January 1950. Proprietors were in possession of different parcels of land. But if they have partitioned it before 26th of January 1950 and brought under cultivation by individual landowners, then they are exempted from Shamla De. Then 3, 4 have been acquired before 26th of January 1950 by a person, somebody who purchases it before 1950, Shamla De, he is also exempted. Is described in the revenue record as Shamla Taraf, Pattis, Panas, and Tholas and not used according to the revenue record for benefit of the village community. This is the opposite of what I just read to you. Lies outside the Abadi De and is being used as Gitwar, Bada, manure pit, house, or for cottage industry. Immediately before the commencement of the Act. Any who knows what Gitwar, Bada, etc., these are small pieces of land which are used for common purposes. And then the most important one in which everybody tries to get away was Shamla De, was assessed to land revenue and has been in the individual cultivating possession of co-sharers not being in excess of the respective shares in such Shamla Day on or before the 26th of January 1950 was Shamla Day was assessed to land revenue. Lots of lawyers come to the court saying it was Shamla Day, it was an individual cultic possession of co-sharers. But they don't come and prove land revenue. Why is land revenue important because if you separated your land, then you will be liable to pay separate land revenue also. So that is another reason why many people are unable to prove that they were in possession before 1950 and in accordance with their respective shares. For this, you'll have to go and go to the list of proprietors. Till you don't have the list of proprietors and you're not shown to be a proprietor, you will not get anything from this. But many lawyers still insist that it makes no difference, etc. But this is the actual language of the law, used as a place of worship, etc., etc. Then lands entered in the column of ownership of record of Jumla Mushtarka Malka wa Digar Haqdara. Now this is the Haryana amendment, where the Haryana has said that Jumla Mushtarka Malkan will be part of Shamla Day. Then we come to 2G. So that's the... So 2G is actually in two parts. One is what is included and one is excluded. What is excluded is if you are in cultivating possession, if you can show your shareholding, if you can show payment of land revenue before 26th of January 1950, or if you purchased it before 26th of January 1950, then you can get your land excluded. So in short, I'm trying to be very short today because actually I'd made a commitment and I thought I must introduce this topic. Otherwise, there's a lot of things which one can go into in lots of details. That will be a rather long drawn out thing, but I thought I would leave it just at the introduction. And so this is what I've introduced. If anybody has any question on this, you can please, because you can unmute them. We'll just leave it at this today.
Yes, sir. On the chat, we don't have, but I will just check it on the YouTube. So we don't have, I think it's otherwise also explained in a very simplified manner. And those who have missed some of the sessions, they can always watch what we have already posted on the Beyond Law CLC, the different aspects of revenue law. So we can end up the session, sir, since we don't have any question.
I'm having a trouble with my...
No, even otherwise, it's a curtain raiser, we can say.
And Mr. M.A. Khan, they does not mean Abadi.
No, his second question was?
And not land.
Yeah.
Riyat. I don't know.
He says, is it similar to Riyat?
That's somebody else.
That is by Rishi.
Sakande in revenue record.
So
anybody else with any other question, or you can send it to Mr. Chatrat and you forward it to me. Basically, I just wanted to introduce this to you, all of you today, because what I find is lots of lawyers, and in fact in Punjab, this is a part of the course of land laws. There's a course of land laws in law colleges. But most people are not even...
So thank you, friends. And thank you to Justice Rajive Bhalla, who has shared his knowledge despite his health issues today. But we all say that positivity does not mean all that positive. Prior to this, it was always positive meant positive. So
actually, I'm very, very sorry for cutting it short because my throat can't take it anymore. I'll have to have another 2 cups of tea to keep it going.
So on behalf of
somebody who's talked about Maharashtra common law, somebody's written a comment about.
No, he's saying is the primary focus would be there on that.
So you can tell him that you'll find somebody from Maharashtra and ask him to speak.
So, thank you to all those participants, and from all behalf of all the participants, we wish you a speedy recovery.
Thank you.
And tomorrow at 9 p.m. we'll be having on practice and procedure on the Food Safety and Standard Act 2016 by Vishwanath V. Angadi, former additional district judge from Karnataka. So do stay connected with us. And again, sir, thank you for all your commitment. The way, despite your health, you have shared your knowledge. Thank you. Stay safe. Stay blessed. Namaskar.